Thank you very much for your patience. It's now session 3 of the Global Forum on IP and Metaverse. The session number 3 is about measures for cooperation among countries related to IP issues in the Metaverse. So first of all, I'd like to invite Mr. Ignacio de Castro, Director of the WIPO Arbitration and Mediation Center, who's going to be talking about the ADR mechanisms for the digital copyright and content-related disputes. Unfortunately, Mr. de Castro was unable to come to Korea, but nonetheless, he'll be able to participate through a video.
Hello, my name is Ignacio de Castro. I'm very happy to have been invited to participate in this global forum on IP and the Metaverse. I am sorry not to be in Korea for this conference. I will be speaking about resolving Metaverse disputes, and I will talk from the experience of the WIPO Arbitration and Mediation Center. The WIPO Arbitration and Mediation Center facilitates the resolution of commercial disputes between private parties involving IP and technology through procedures other than court litigation. The center is part of WIPO, the World Intellectual Property Organization, and that gives the center international neutrality. The center, being part of WIPO, specializes in the different areas of intellectual property and technology, and we see all types of disputes in these different areas. One of the main features of the center is that we have a very extensive list of WIPO mediators, arbitrators, and experts who are specialized in the different areas of IP and technology, and these experts will help us to deliver efficient results in each particular dispute. We offer different procedures: mediation, arbitration, expert determination, as well as domain name dispute resolution services, where we handle a very large volume of cases. Just to focus on the two procedures that may be most relevant for this presentation, mediation is an informal consensual process where a neutral intermediary, the mediator, will help parties to reach a settlement of their dispute based on the parties' respective commercial interest. The mediator cannot impose a decision, and the settlement agreement has the force of a contract, of an agreement, and this procedure leaves open the options to go to court or to go to arbitration if the parties are not happy with the result of the mediation. The second procedure is arbitration. Arbitration is also a consensual procedure, but only when the parties agree at the beginning to move to arbitration. Once they have agreed to go to arbitration, the parties will be bound by the result of the arbitration. The parties will have to decide whether they want to have 1 or 3 arbitrators, and the result of the arbitration will be final and binding, and that is called an arbitration award. The arbitration award will be based on the parties' rights and obligations, not based on the interests of the parties. And the big advantage of arbitration is that the arbitration award can be enforced internationally through the New York Convention. Normally, arbitration also excludes the court options, so it's basically a final decision issued by the arbitrators, and that is enforceable internationally. If we move now to the caseload of the center, we deal mostly, well, the main area for us is patents, where we deal with all types of patent disputes. We also have a big share of copyright disputes. Increasingly also, these are digital copyright disputes. We also handle trademark disputes and many IT-related disputes, which may be particularly relevant in this environment. The parties in WIPO cases come from all over the world, and we are seeing an increasing number of parties based in Asia. Traditionally, we always had parties based in Europe and the US, but Asia is growing very fast, and particularly we are seeing an increasing number of parties from the Republic of Korea. The source of these cases traditionally was contract clauses that provided for mediation or arbitration. But increasingly, we are seeing an important number of cases that are submitted to the center where there is no clause in a contract. Most of the cases that we deal with are international, and the languages, the main language continues to be English, followed by Spanish and Chinese. In terms of the settlement rate in these cases, we have an important settlement rate, more than 70% in mediation and 30% in arbitration. The evolution of the caseload is very positive. In 2021, we had a more than 40% increase of the caseload, and this year we are expecting a very large increase, more than 70%. So moving now to examples of digital disputes referred to WIPO ADR. So we see here disputes in all these areas relating to audiovisual works, musical works, photographic works, social media, issues relating to platforms, to online content service providers, many disputes relating to software, outsourcing, mobile applications, videos, and online games. As a result of these examples of disputes that we are seeing in the area of digital copyright, we have been doing some very interesting work in this area, and this work has been supported by the Ministry of Culture, Sports and Tourism of the Republic of Korea, and we have produced a survey on ADR for digital copyright and content dispute. This survey is available online. We don't have time now to share with you most of the results of the survey, but I will share with you some very brief highlights on this survey. First of all, I should say that we had more than 1,000 replies to the survey, and we also conducted a number of interviews, and the results are summarized in this slide. So we saw here that the top dispute areas are software, musical works, advertising, and literary works. The main types of disputes are infringement and licensing, and the priorities of parties when resolving disputes are the speed, the cost, the quality, outcome, and enforceability. The most popular dispute resolution mechanisms are notice and takedown, and followed by court litigation and by mediation. And the top technology tools to speed up the resolution of these disputes are the use of online submissions and video conferencing. And I should have mentioned that as a result of COVID in the last 2 years, the vast majority, 95% of our cases have been conducted entirely online. And this has been extremely positive for the parties because it reduces the time and the cost spent in these procedures. In the next slide, you see the perception of the different dispute resolution mechanisms for these digital copyright disputes. And you see that mediation and conciliation are considered to be particularly suitable, as well as notice and takedown procedures. Court litigation is a bit more mixed. Arbitration is considered to be relatively suitable, but there is not a lot of knowledge about expedited arbitration, and certainly what parties don't seem to appreciate is when they have to conduct court litigation in a different jurisdiction. Of course, that is because often they're not familiar with those procedures, and because it may be expensive for them to instruct lawyers in that foreign jurisdiction. Expert determination has not been a procedure that is very familiar for many parties, but we have been working in this area And we have been in particular looking at recent legislation in Europe. There is a European directive on copyright and related rights in the digital single market. And as part of that, Article 17.9 of the directive refers to the use of protected content by online content sharing service providers, and how these online content sharing service providers should put in place an effective and expeditious complaint and redress mechanism that should be available to users of their services in the event that disputes over the disabling of access to or removal of works or other subject matter uploaded by them is necessary. And the member states of the European Union shall also ensure that out-of-court mechanisms are available for the settlement of these disputes. So based on that, we have developed a procedure that can deal with these cases in a very fast manner. The procedure normally would take place within a period of 2 weeks. The Center has also been working in the area of alternative dispute resolution for video games and esports disputes. And there we offer case administration. We have also a special list of experts with particular expertise in this area. We offer procedural guidance and training, and we are considering also the development of tailored ADR procedures, which will be, of course, focusing on online conduct. Moving to NFTs and Metaverse disputes, we are seeing the use of ADR clauses, WIPO ADR clauses already in general terms and conditions. And we are also seeing that as part of smart contracts in particular. We are looking at disputes in the different, involving different parties, users against platforms, users against users, as well as users and service providers. And these disputes may relate to all the different areas of intellectual property, copyright, trademarks, software, also even patents when it comes to virtual reality hardware, for instance, headsets, and even issues relating to designs or to image rights, as well as issues relating to advertising, which we have seen from time to time referred to WIPO, mediation and arbitration. So moving to the next slide, here you have a model clause, which is the clause that we see most often. It's a clause that provides for an initial phase of mediation, followed by arbitration or expedited arbitration. This is a clause that can be adapted, and what we are seeing now is that although the parties will specify always a place of mediation, a physical place of mediation, they also are sometimes adding to this standard clause that they would like that their procedure is conducted online, and this may be particularly relevant to some disputes in the metaverse. So, of course, we are very happy to have any questions. Please don't hesitate to contact us through arbiter.mail@wipo.int. You can also contact us in Korean. We have a colleague, my colleague Aram Kwon, who is also going to participate in one of the sessions of the conference. We'll be very pleased to reply to your questions in Korean. So please don't hesitate to contact us. And finally, we have just created a center presence on Kakao Talk, and you can also follow us on that Kakao Talk platform. So for now, thank you very much, and I'm very sorry not to be in person at the conference. Thank you. Thank you again.
네, 영상으로 발표
Thank you very much for that presentation on video. Next, we will hear from Professor Kyu-ho Lee of Chungang University, Proposal of International Solutions in Case of Infringement of Intellectual Property Rights on Metaverse. I will invite him onto the stage. Good afternoon. My name is Kyu-ho Lee. I'm professor at Chungang University. I will be speaking about on the metaverse. If there is transnational IPR infringement, how we should respond to those. So more specifically, I will be speaking about the private legal relationship and public legal relationship in those two different perspectives. So generally speaking, to look at the discussions that are taking place on the international arena in terms of the applicable law, the applicable jurisdictions, the offshore application of actually practicable law, it's mostly dealing with private legal relationships. However, when we're talking about offshore application of practicable law, it's sometimes confusing whether this should be in the realm of private legal relationship or public legal relationship. And in practice, in international discussions in academia, sometimes the people who are involved in the discussions aren't very clear on the difference between private legal relationship and public legal relationship. So when I was writing a report for the World Comparative Legal Studies journal, I found I was confused myself. So I believe that we have to discuss and distinguish very clearly private legal relationship and public legal relationship. So this is why I am distinguishing between those two. So to talk about private legal relationship, we first come to the international choice of court, and in particular, if there's agreement on the which country court this should be discussed in, there has been this year an amendment to the Korea private international law. And it says that according to the Hague Convention on Choice of Court Agreement, that the choice of court has to be presumed. So in 2022, when we amended the Korea private international law, we only had about 3 provisions: general terms and consumer contract and employee contract. Only those 3 were discussed in terms of the choice of court, but the choice of court has been applied widely across all relevant items. Now, around the world, if we look at the bill-related cases and insurance cases and maritime cases and family court cases, all of those areas are addressed for the first time in terms of choice of court. For international cases, Korea would be the first country to determine all of those. And the Cliff Principle, the ALI Principle, and Korea-Japan joint suggestion, and also the Kyoto guidelines that were issued by the World International Law Association. All of those suggestions have been worked into the bill, and this was tabled. This was suggested to the Ministry of Justice, and it had passed the this was actually ratified by the National Assembly. So this was quite an achievement in terms of international private law society. So here, if we look at the Korea's private international law, it's described in Article 8, but I actually have to discuss something else. I'd like to talk about neighbor Zepeto service. As for neighbor Zepeto service, if we look at their terms of service, there's choice of court agreement provision, but there's no provision on applicable law. And prohibited acts include infringement of intellectual property rights. But in front of intellectual property rights, we see the expression trade secret, and this begs the question whether trade secret is included as an intellectual property right. But in Korean law, a trade secret is characterized as intellectual property, not an intellectual property right. But if we ask American attorneys, most of them will say that trade secret is intellectual property right. So whether trade secret is classified as intellectual property or intellectual property right differs. Sometimes the right is generated, and sometimes they would look at the actual practice, and also it would depend on the jurisdiction. So actually, in fact, a Korean company, when they were signing a contract with a US company for the provision about dispute settlement, cases of IPR would be brought to a certain court in California, and other IP-related, intellectual property-related disputes would be brought under the Korean court. So if it's IPR related, then it would be brought to the United States, California, a certain court in California. And if it's related to intellectual property instead of intellectual property right, it would be brought to an arbitral panel in Korea. And Article 8 brings in new details.
이 조문이 바로 거기에 관련된
Article 8 of the Korean Private International Law, here on the slide. So Hague International Convention on Choice of Court Agreement. So exclusive choice of court agreement is recognized here. However, the fact is Korea has not ratified this Hague Convention, but in academic circles, people are strongly demanding that the government that Korea also ratified this, because Singapore is one of the Asian countries that has ratified this. But in terms of IP disputes, this will only be applicable in a limited scope, because most of the terms of use for Metaverse services is about consumers. So we have to exclude the part of consumer contract, and then there would be employee agreement, and also the copyright infringement would also be dealt with separately. And even if we ratify the Hague Convention on Court of Choice Agreement, it will only be partially applicable to intellectual property right suits. And in terms of consumer contracts, we have to consider the following, because in the terms and conditions, most of the users will be classified as consumers. The definition of consumer could be passive consumer, a consumer entering into contract with another for a purpose other than occupational or business activities. And as for a passive consumer, they would fall under the consumer contract articles. And their habitual residence, if they are habitually residing in Korea, then the court of jurisdiction would be in Korea. So even if there's an exclusive choice of court agreement, according to consumer contract, the suit might be brought into Korea. So this is quite consumer-friendly provision. But in a Google-related case that went up to the Seoul High Court, there was a case where whether the user was a consumer or not had become an issue. Because if the user had been doing occupational or business activities, it was not a consumer contract, but it was acting as a business person, not as a consumer. And in that case, if we're talking with Google, then the case would have to be brought to California. And the terms of use for Metaverse services, in particular, if the Metaverse platform is operated by a company in the United States, then if the user is not classified as a consumer, then the court would have to be brought to the United States. The case would have to be brought to United States. The special choice of court agreement would not be applicable. And we can see related provisions on the slide. Then in terms of consumer contract, about international court of jurisdiction, what would be the applicable law? If we look at the Korea Supreme Court cases, it would be Lex Fori. However, with the Korean Private International Law of 2022 amendment, the applicable law would be law of the country where the court chosen by parties are located, and this also is in accordance with the Hague Convention on Choice of Court Agreements. So you could say that Korea has not ratified the Hague Convention, but we have brought in quite a lot of the provisions of the convention into our own domestic law. So we take a closer look at Article 8 of the Korean Private International Law. So in Professor Jiyoung Han's presentation in the morning, we heard him supporting Korea's case law, and one element that was a problem in the international arena was about the reasonable connection. So it had to have reasonable connection with Korean courts to establish the exclusive agreement. So if a foreign court is determined as the exclusive court of agreement, for example, if the California court has been determined as the exclusive court of agreement, there should have to be a reasonable connection with the California court. And if not, then it would be invalid. So that was the previous situation of Korea case law. But this has been abolished, and this is the most remarkable change in the recent amendment. So according to the amended new private international law, the reasonable connection requirement has been eliminated, and this also is in accordance with the Hague Convention on Choice of Court Agreements. And in terms of making your intent expressed, writing by electronic means is allowed, and this is also in line with the international trends. And this is the provisions, related provisions. Now I would like to turn to Article 38. There's a special jurisdiction on IP contracts, and on Article 37, there's a special jurisdiction for IPR infringement. In particular, I'd like to draw your attention to Article 39. So there are three areas. If act of infringement is in Korea, and if the outcome had arisen in Korea, and if it targeted Korea, then it could be brought to Korea. So if the Infringement Act had targeted the Republic of Korea, then it could be brought to Korean court. And private international law society members are discussing what the target place means. So in Europe, the target place is included or captured by the place where the effect had taken place, the result had taken place. I believe that the National Assembly believed that these two were different. The target place and the place where the result had taken place are to be understood as the same thing. So the target place should be understood as included in the place where the result arrives. I think there was a confusion on the part of the National Assembly, and I was referring to Article 44 and 39. Now, because we have special jurisdiction in tort cases, there's a gray area for unfair competition acts and infringement of trade secrets. Where do those fall? But when we're looking at the relationship between laws, we're looking at the applicable law. But when we're looking at jurisdiction, there's not much international discussion that has been done on this issue. So if we're not able to use the expression of a legal relationship determination, then we can't use the law suit or proceeding relationship. So whether trade secret infringement, from the perspective of private international law, it might not be a legal act. And from one perspective, it might be understood as IPR infringement. So in Korea, domestic law, the trade secret is, if trade secret violation is understood as an illegal act, but according to private international law, it is considered as IPR infringement. Now I would like to talk about the law applicability in terms of Metaverse. So the party's autonomy applies here, but if it's a consumer, then we should apply Article 47. In paragraph 1 of Article 47, we find that the habitual residence of the consumer, the protection given by the mandatory provisions of the country where the habitual residence of the consumer is located shall not be deprived. And the issue here is the regulation on the terms and conditions. So there are regulations on terms and conditions for each country, and Korea also has one. And according to this law, if the applicable law is a foreign law, then if it turns out to deprive the Korean consumer right, then whether we can apply the terms and conditions law is the issue. But according to Article 47, the mandatory provisions, it applies to Korean situation, and the terms and conditions law is also protected. But if the Metaverse user is not established as a consumer, then how should they be protected? How they should be protected? Then we could refer to Article 20, international mandatory provisions. However, the terms and conditions Regulation Act doesn't escalate up to international mandatory provisions. And so the applicable law would be the law on which the parties had agreed on. And most users who have done commercial activities, they won't be construed as consumers. So that would determine the applicable law. Now, for law applicable to non-contractual relationship, law applicable to establishment, transfer, infringement of IP rights would mostly be lex loci protectionis. Professor Jenkins seems to see this as a different law, but Korea private international law says that this clearly states that this is lex loci protectionis. But employee invention, we don't see a lot of cases around the world that had rulings on the Supreme Court level. But Korea's Supreme Court ruled very clearly that the employment law is applicable. So the law that is more favorable towards the employee can be applied here. And in terms of unfair competition, infringement of trade secret, or theft of idea, or counterfeit products, in areas where Unfair Competition Prevention Act can be applied, which should be the applicable law. We have Korea High Court rulings, and it's determined as depending on the characterization. And some people say that let's say Article 40 should apply, but some people, like myself, would say the following. So in image design, if an image design is unregistered for a product, a virtual product, then anti-unfair competition law could apply, but also Article 35 of Commercial Act could apply. Or rather, Article 35 of Trademark Act could apply because it could be an indispensable trademark that is a 3D presentation. So the most clear and straightforward way to approach this is to apply lex loci protectionis. And if it's an image design, whether we should see this as a 3D or hologram or motion mark is going to be important. Because if it's a 3D design, then it can be a unregistered mark. But if it's the other two, then Article 35, Paragraph 1 of Trademark Act cannot be applied. So how we are going to view so what type of image design it is will also be very important. And also there's a case pending between the same parties before a foreign court. We can apply lis pendens. And also another thing that might be an issue, whether punitive damages that have been ruled by American courts can be imposed in Korea. So IPR and unfair competition, anti-unfair competition all bring in the treble damages. And in particular, according to subcontracting law, punitive damages that were ruled in Hawaii, because this is not counter to Korean public morals. It has to be recognized. So aside from copyright law, most IPR law in Korea, treble damages might be recognized. But one thing that should be mentioned here is injunction rulings for offshore. In a case that involved DuPont, extraterritorial application injunction issued by a court of a foreign country, colon, was served in injunction. The outcome was, the ruling was an injunction from federal district court in Virginia, so that they couldn't sell products in that particular area for a very long time. And this was contrary to the public morals and standard decency of Korea, so this could not be carried out in Korea. Now we should turn to public legal relationship. We can look at it in three perspectives: jurisdiction to prescribe, jurisdiction to adjudicate, and jurisdiction to enforce. In terms of adjudicate, jurisdiction to adjudicate, this is about the international jurisdiction. And in terms of prescribing, whether under the Telecommunications Act, whether it can be extraterritorially applied. So when we're referring to criminal law or administration law, extraterritorial application takes place quite often. And another thing that we should consider is, in terms of jurisdiction to prescribe, prevention of unfair competition and territoriality doesn't apply here. So extraterritorial application can take place unless there is discussion that determines otherwise. So border measures, website takedown measures, those areas should be paid attention to, in particular because this can extend to extraterritorial application, and this is quite important. Now, these situations arising, to solve these situations, I have came up with 7 solutions. First is taking a look and reviewing transparency reports from each Metaverse platform providers. And according to Telecommunications Act, the platform providers are required to turn in transparency reports, and so we can encourage through international organizations and public domestic institutions to provide a uniform language across those transparency reports. And about international jurisdiction, Korea has, as I mentioned earlier, Korea is the first country to prescribe this, so we should try to spread this effort. And third of all, there are principles here, and these have been discussed at the Hague Convention on Choice. This has been discussed in Hague, and in terms of private international law, it was hard to come to a consensus. And Professor Jenkins-Berg and Professor Dreyfus made the ALI principle. And Axel Metra and other European professors came up with the CLIP principles. And to counter to this, Korea and Japan had come up with joint proposals, and I was part of that effort. And perhaps we could bring all 3 groups together, and in the International Association for Private International Law, and they came up with the Kyoto Guidelines. They actually did that, and came up with the Kyoto guidelines and dealt with the applicable law and etc. And one thing is that infringement of trade secret and unfair competition are understood as, they are treated as IPR infringement. And fourth of all, we could think about concluding bilateral or multilateral agreements. The first is the first trade deal that came between the US and China. And one very important part of that was the trade secret part. In particular, in 2019, if I look at the 2019 Unfair Competition Prevention Act of China, we can see that the law has been amended very much to recognize what had been discussed in that US-China deal. And if there's a bilateral agreement, then the territorial principle does not apply. So we can form international consensus. However, if it's a multilateral discussion, WIPO has to reach an international consensus on trade secret and unfair competition practices being viewed as IPR infringement. And another suggestion is expansions to territoriality principle. Privacy or trade secrets or publicity or unfair competition, these areas, whether territoriality principle should be applied to which extent across those areas, that should be discussed in the international forum. And what has also been missing is jurisdiction to prescribe in terms of public legal relationship. There should be more active discussion on this. And next, the arbitral panel and the mediators, their work in the metaverse could be performed in the ADR framework through the avatars. So they could refer to 7 principles, not 3 principles, but 7 principles. So neutrality by third person, prudence and independence, and fairness. These 4 are traditionally long-standing principles that apply to ADR, but we need 3 more additional. So what is most important in terms of the additional principles would be equivalent of identity of participants. So in ADRs, avatars are actually active, but one avatar doesn't represent one person, one identity, it represents a group. So some conditions apply, their wage or employee number or code. That is the only clue where we can determine who is standing behind that avatar. So we have to have more clear identity of participants, and we should also have the condition or principle of secrecy and perfection of cybersecurity. And my last proposal. So most metaverse platform operators are multinationals from OECD member countries. To take the example of Zepeto users that is provided by Naver, 300 million users are already registered and around 90% are foreigners. And most of the platform operators are multinationals from OECD member countries. And multinational companies have to abide by the OECD multinational guideline. This is a soft law, but because of the naming and shaming strategy of OECD, they have to issue annual reports, and if they don't abide by the guidance, then they might be kicked out of the market. And Korean companies had actually faced with the situation in the European Union. And consumer protection is a very contentious area here. So we have to make better use of this situation. So those were my 7 proposals and suggestions. Thank you for your attention.